A preliminary hearing is like a mini trial. At a preliminary hearing, you have a right to cross-examine witnesses, put on evidence, and testify yourself if you want to, or not testify at all. After the judge hears the evidence, the judge will determine whether there's probable cause that an offense was committed and whether there's probable cause that you committed that offense. One of the purposes of a preliminary hearing is to ferret out groundless and improvident prosecutions. The way this is done is by giving you certain rights at the preliminary hearing. The state can put on evidence by calling witnesses or introducing exhibits. You have a right to cross-examine those witnesses, and then after that, you have an opportunity to put on evidence yourself through witnesses or other evidence. You also have a right to testify and a right to not testify. Now, whether you would testify is up to you and your attorney to determine whether that would be beneficial. However, one thing to know about a preliminary hearing is that the judge is required to view the evidence in the light most favorable to the state. This means that even if you put on evidence that contradicts the evidence that the state has put on, the judge has to view the evidence in the light most favorable to the state and can ignore the contrary evidence. In fact, case law says it's not the judge's job to sift through the evidence and give some evidence more weight than other evidence. That's the job for the trier of fact or the jury. At a preliminary hearing, the judge is simply determining whether there's probable cause that an offense was committed and that you committed that offense. If the judge finds that, then the judge will bind the case over for trial. And if the judge finds that there is not probable cause, then the case will be dismissed.